So welcome everybody to our webinar today, Trademarks 101 for our cannabis and hemp brands. My name is Brandon Kurtzman. I'm a partner at Vicente. I'm based out of the New York office. It's my pleasure to be here with my two co-panelists, Chelsea Spencer and Paul Stevenson, who are our IP counsel. And I'm basically going to turn this over to Chelsea and Paul to go through this, I'd say very important and often overlooked issue when it comes to cannabis companies and hemp companies and what we see in the brands. It's as you're developing your brand, I think that, it's overlooked because people don't take into account that, this is something that you're trying to protect and you need to protect in order for it to grow properly. And if you don't do so, there tends to be repercussions. Chelsea and Paul are gonna, walk through sort of the high level stuff on this issue and this topic, and provide you with some knowledge and sort of like next steps and things to think about as you either are starting a brand or have an existing brand and growing from there. So I guess with that, I'll turn it over to Chelsea and Paul to introduce themselves. If anybody has questions throughout the presentation, they can pop them in the chat and we'll try to answer them as we're going along. But then we will try to save a little bit of time at the end to get anything we missed. And of course, if we miss anything, then we'll get back to you, via email. So without further ado, I will turn it over to Chelsea and Paul.
Good afternoon, everyone. I am incredibly excited to be here today speaking to you about two of my absolute favorite things, trademarks, where I pretty much started my career in cannabis. I've done both for 12, 13 years at this point. As you'll hear today, trademark law itself is a little bit difficult to understand throughout the registration process, and you add in the complexities of either hemp-derived THC or cannabis-derived THC or CBD, and it adds a completely different level to it. Yes, Ruth, if you have any questions in the chat, as Brandon said, feel free to drop them in the chat. We're watching that. Can we advance the slide? We're going to start with a threshold understanding of what is a trademark today. And it feels a little silly to do this, but oftentimes there's some misunderstandings between the various areas of what we call soft IP and then hard IP, such as a patent. Trademarks are words, symbols, slogans, devices that identify a source indicator. If I were to hold up, I normally have something on my desk I can hold up, but if I had, let's just say, a Coca-Cola can, and I held it up without the Coca-Cola portion of the can facing you, I'm quite sure that nearly everybody in the audience today would immediately be able to say, she's drinking Coca-Cola. That's because you're identifying there you go, right? Coca-Cola. And I'm sure every single person would say that's Coca-Cola. That's a trademark, but the exercise we've just engaged in is what's called secondary meaning, and it's the entire point of a trademark. It acts as a source identifier. A consumer sees it, they immediately know who and where it comes from. So on the screen here, I've put two examples of what we would call our standard trademarks. You've got Nike, the word mark. This is actually a result from the USPTO. It's not the registration certificate. It's through tests, which we'll get into how you search for these things. But this is one word mark for Nike. They obviously have 50 plus at this point, from everything from swimming earbuds to socks to there were some pretty funny ones in there. And on the right-hand side of the screen, you have what we call a design mark. And this is the logo mark. If I were to show you that Nike swoosh without saying anything about the company behind it being Nike, most of you on this call would immediately know that's the Nike swoosh. That's secondary meaning. It's acting as a source identifier. If you've bought Nike and had a good experience with it, when you see that swoosh, when you see the words Nike, you know it and you trust it. And we're also going to talk about policing counterfeits today, which is fairly important when you are a larger brand and even a cannabis brand. I'm sure many of you have seen the Reefer's Pieces and the Stony O's and the knockoffs of general consumer food products. If someone has an adverse experience with a product that they believe is yours, but it's not really yours, that's what we call consumer confusion. And it can really lead to some harm for your business when a consumer thinks that you're the one behind these subpar products when actually it's your competitor who's riding on your coattails. Next slide, please. I've put in some examples of atypical marks. These are not ones that most attorneys will ever get to experience in their career. I should have put a trade dress design mark in here. The first is a sound mark. Anybody know what that is? Drop it in the chat. Yeah, that is a famous registered sound mark. You can register a sound mark. We even have registrations on things like the sound of a Harley Davidson starting up. NBC, good job, Howard. It's NBC. That's one of our longest standing and first registered sound marks in the entire United States. The second one there, if you were to walk down a street and see a woman wearing a shoe with a red sole, drop in the chat, anybody, if you know what that is. This is an example of a color mark registration, which after a decision by the Supreme Court called Qualitex, it's quite clear that color is registrable as a trademark. However, that's generally reserved for what we call these behemoth companies, the T-Mobile, Magenta, Louboutin. Good job. Yes, exactly. So if you saw we're doing these live exercises in secondary meaning, and it doesn't say Louboutin anywhere on there, but you immediately knew that was Louboutin. So when it comes to registering color, they own a specific Pantone. Tiffany owns their specific Pantone color blue. These marks are notoriously difficult to obtain. I've done one in my entire career. It was on some interior trade dress. They rarely come along. They are the most fun to register. They're incredibly difficult to get through. Last but not least, and this may blow some of your minds, you can obtain a trademark on a smell. The USPTO has a registered mark that covers the scent of a sweet, slightly musky vanilla fragrance with slight overtones of cherry combined with the smell of salted wheat-based dough. Yeah, Play-Doh, everybody knows it. And it's true. Like if your kid is playing with Play-Doh, you know that smell. That's that consumer recognition. That is the inherent value in your business's trademark, the fact that consumers immediately recognize you. And the wonderful thing about a trademark is it is an appreciable asset. Before you start using it, it's worth nothing. Some of the largest companies in the world today, if they sold solely the trademark off of their portfolio, it is a multi-billion-dollar sale at that point. So that's a quick intro on what exactly constitutes a trademark. Paul, I will turn it over to you.
All right. Thanks, Chelsea. And if we could go to the next slide, please. So Chelsea was focusing on, general what is a trademark, and I'm going to pivot to the importance of registering a trademark. And towards the end, Chelsea did note that indeed, yes, trademarks are appreciable assets, so their worth grows as more consumers begin to recognize the brand over time. But also, obtaining a federal trademark, it provides the owner with the exclusive right to use that trademark throughout the nation. And also, once you get a registered trademark, you can sue for trademark infringement in federal court against those using an identical or a confusingly similar trademark to yours. So you could sue in federal court for trademark infringement and seek to recover damages. And if there's willfulness, you can also potentially recover attorney's fees. And also another perk of registration is you get to use that symbol with the circle and the R after your trademark, which we're all familiar with. It provides a presumption of ownership, and Chelsea will get into this a little bit more, but it also acts as a bar to identical or confusingly similar trademarks. And another interesting facet is that you can submit a recordation application that contains your trademark certificate, your trademark registration certificate, with the United States Custom and Border Patrol, and you can teach them how to recognize counterfeit goods. And these are the pictures, some pictures that we pulled of some counterfeit goods that were seized by the U.S. Custom and Border Patrol. Obviously, these are knockoffs of the Apple earbuds and then some Gucci purses as well. But these were seized because, or I think they're Gucci purses. I'm not 100% sure myself, but they're counterfeit goods nonetheless. And they were seized because the recordation application was submitted to the Border Patrol and they were taught on what they need to seize because of their recorded trademarks. And if we could go to the next slide, please. All right, so kind of taking a step back, the pathway to registration contains 3 main steps, and that is selecting your trademark brand, clearing that brand to make sure that it doesn't present a likelihood of confusion refusal with a identical or confusingly similar mark. And then thirdly is to apply for and to protect your brand. And if next slide, please. So the first step is to select your trademark brand, and this is critical because this is where this is the launching pad essentially. So trademarks are categorized on what's called the sliding scale of distinctiveness, and they range from generic marks to highly distinctive marks, which highly distinctive marks are suggestive marks, arbitrary marks, and fanciful marks. And so the weakest marks are generic marks, and they are just generic of the goods or services that they cover. So we provided an example of aspirin for pain relief medications, and there's also, think about Band-Aid for bandages. It's just a generic way of, or generic description covering the goods or services associated with it. And then merely descriptive marks are marks that simply describe characteristics, features, goods, ingredients that are used with the goods or services. So here we provided American Airlines, and that is a trademark for airline services, typically throughout America. And these generic and descriptive marks are almost always refused registration with the United States Patent and Trademark Office. And we see so many prospective clients and even current clients come in with these merely descriptive marks. And we have to go through typically long paths of telling them that that won't be accepted by the USPTO. It's merely descriptive. So California hemp for hemp goods made in California, it will be refused, but that needs to be hammered home. And that's one of the reasons why we're having this presentation today. I saw something come up about Band-Aids. Yes, that's kind of
That was
Band-Aid.
me adding a
That's
fun
you. Yeah.
fact.
Okay.
The jingle was changed because Band-Aid faced a genericide challenge and they survived. So now the jingle says, "I am stuck on Band-Aid brand." Obviously, I didn't come to sing today, but that's exactly why they amended it, because they're trying to avoid exactly what we just saw, happen live, the use of Band-Aid as a generic mark.
Right. And so next on the sliding scale are suggestive marks. And these are marks that require kind of a next step in logic in order to reach a conclusion regarding its nature of goods or services. So we provide an example of Coppertone for sunscreen. You can also think of Jaguar for a fast sports car. It requires that next step to think that Coppertone covers sunscreen goods. Then moving on in the sliding scale are arbitrary marks, and arbitrary marks are those that they have terms that actually have a definition or an actual meaning, but they don't immediately associate with the goods or services. So Apple for phones, Apple obviously has a definition, but it doesn't immediately associate with phones. We will get to some more of these hemp questions towards the end of the presentation. But I'm going to just continue with, yeah. And then finally, the strongest trademark is our fanciful trademarks. And fanciful trademarks are those that are invented solely to act as a trademark. So Exxon, it's a completely made up word, but we all know that it's for gasoline or gasoline services. And then another example is Haagen-Dazs, which is for ice cream, as we all know, but Haagen-Dazs is actually a completely made up phrase. And if you could go to the next slide, please. Okay, so we went through lots of bars to registration, and This is just the statutory guidance on what is and what is not registrable. So a few more bars include, it's kind of common sense. Don't search for or don't try and apply for trademarks that have scandalous material or immoral material. I also touched on geographically descriptive marks, such as California hemp for hemp-based goods or services. Chelsea will get into confusingly similar marks. And then also you can't trademark functional matter such as uh, the coat of arms or also the name of living persons. But you can, a little like caveat of that is if you get the written consent, then that is sometimes permissible. So next slide, please. All right, transferring it back to you, Chelsea.
Yeah, this is me. So I'll go ahead and answer the question that was in the sidebar on searching. If you're selling products internationally, number one, you wouldn't be eligible for registration in 99% of the countries in the world absent use in that specific country. So there's two types of filing regimes. There's use-based, which the United States is. You gain common law rights in your trademark the minute you begin to use it. Then there's first to file. China is a first to file jurisdiction. So if, for example, that Nike trademark, if someone at Nike doesn't do their job and the main Nike trademark lapses, anyone can go file for it in China. And if they get it, they can hold it hostage. China is working on that with some lower level IP courts to resolve some of those issues. But country specific registration gets very, very specific. Generally, what you do is you work with, as U.S. counsel, I direct the activities of foreign counsel. I'm obviously not licensed in. I did one in the UAE this morning. I was communicating with UAE counsel on that. What I do want to show all of you today, because it's very helpful in once you get past those bars, is this even registrable? You do want to be, the farther you are on the sliding scale of distinctiveness, the higher the chance that we can get you through to the registration absent a confusingly similar mark. Confusingly similar means if a consumer saw this, would they believe that it was your brand? So if you saw a black pair of shoes with a red sole going down the street and you thought they were Louboutins, but they were some knockoff Fouboutins, that's precisely consumer confusion right now. And actual confusion is the most probative evidence you can ever bring me if I need to write a cease and desist or a demand or go to court. So anytime that you have someone come in and say, hey, that store down the street, they're selling, I don't know, let's say you have a product called Puff a mic. I don't know. I'm just looking around my office. And somebody comes in and they're like, hey, store down the street is selling Puff a like. Is that you? You need to take a written record of that for me, because that is literally the most probative evidence that I can go into court with to say here was a real consumer in the wild and they came in and got very confused. So as you're going to select this mark, you first have to get past those preliminary bars. Generic marks, never registrable. Merely descriptive marks, never registrable unless you have proof of secondary meaning. So if you call us after this and say, hey, my mark is green bud and I'm selling cannabis, can I register it? My answer is going to be, probably not, bud. That's pretty descriptive right there, unless we can show secondary meaning. And I can often do that, for example, with dispensary outlets, if you have substantial media features, you've been featured in Forbes and Times, you've won 70 plus awards for dispensary of the year, you've spent $5 million in advertising, it's still an uphill battle to get you there with a merely descriptive mark. So when you're sitting down and selecting your brand, you want to be suggestive onward. When you pick, go ahead, Paul.
I was going to just say it does take extreme scenarios, though, to achieve secondary meaning. I mean, typically it requires a lot of money and effort, but also additional things such as a client were getting closer to registration of their mark. They even had a race car, and the race cars were part of their marketing campaign. And we submitted pictures of their race cars and them coming in first or second place in certain races. So that was also evidence that we attached to our secondary meaning argument, and we're getting closer and closer to registration for that mark. But I thought that was an interesting tidbit on achieving secondary meaning.
It is. And the biggest favor you can do for us if you're in the brand planning stage is don't pick a merely descriptive mark. And it's not even a favor to us, it's a favor to your pocketbook. We have to go rounds and rounds with the examining attorney. We'll get into the process and how that goes through. But after you select a mark, check where it is on that spectrum. Then you go through the bars to registration. Is this a living person? Do I have their consent? Am I trying to register some insignia of the state or the government? Am I trying to, register something that's geographically prescriptive? If your answer to that is all no, then you're ready to go use what is known as TEST, the Trademark Electronic Search System. And it is not a intuitive system. It is not fail safe. So I've made a little video here, which we can go ahead and start playing. And it's going to walk you through the search process here. So if you just Google trademark test, TESS, you're going to come here. And I went to that word menu on the left and dropped it down to word mark. So I'm looking for a word mark called pineapple blue. I hit search. It has brought up about 25,000 results. So that red means the mark's dead or abandoned. Somebody either failed to file a renewal or they're just not using it. So I unclicked dead off the left, took it off. This is showing you, theoretically, every registered mark in the USPTO that incorporates the term pineapple. Head up to the top right and click expert. And on the left, you'll see your classes. Trademarks are registered in 45 different classes. I think I limited this one. I went to smokers. So if I'm doing a smokers article and, pre-roll, cigarette, ashtray, anything like that goes in class 34. I limited the search to 34, left on coordinated classes. Those are related or previously coordinated classes via international treaty. And I'm searching for pineapple blue now in this specific category. And as a trademark attorney, I would absolutely expect to get what's called an office action from the USPTO. When we submit the application, it will sit there. Their processing time is getting a bit quicker, but it's going to sit there anywhere from 6 to 9 months. An examining attorney is assigned to your individual file. They look at the application to determine if any of the bars to registration apply. Most cited one is always going to be likelihood of confusion. And unfortunately, and I'm not the only one with this sentiment, trademark practitioners nationwide we have a big listserv where we bemoan the quality of the USPTO examination process lately because the refusals are getting more prolific on less of a legitimate basis. I'm trying to think of a nice way to say. And I don't know if it's that the USPTO has reduced some internal training standards, if they're losing older examiners. I have no clue, but marks that I used to be able to say with nice certainty this will sail through registration, it won't be cited. We got a refusal saying that a podcast was confusingly similar with a jar of jelly. In no consumable realm would a consumer walk into Walmart and be like, oh yeah, that's that podcast is grape jelly. But then we have to go back and fight that with the USPTO. So here, I would absolutely expect an examining attorney to issue me a refusal for pineapple blue. Initially, it's called an advisory refusal because in US trademark parlance, the first word of the mark is typically the most dominant. And I have no qualms. I would be able to argue back and overcome that refusal, but it's the process that you have to go through. Next slide, please. So that's your first step, is clearing that. And we do that as well. That's what's called a very preliminary knockout search. I'm just quickly looking in the USPTO records to knock it out for you. But what I also tell people, Google is your friend because you have no requirement under federal law to register your trademark. So Google it. See if somebody out there is on Instagram or Facebook or TikTok or Twitter or whatever the kids are on these days using that mark, because again, common law usage creates priority. And the last thing you want to do is pay to get your mark registered, start openly using it in US commerce, and then here comes a cease and desist letter from somebody saying, what are you doing? I've been using this for 7 years. Expressly, abandon that application and stop using my mark. So after we do the preliminary clearance and we come back to you and say, it's our initial opinion, this is preliminarily clear, we always advise, and courts will look at this in an infringement case, we always advise that you run a full domestic clearance search. And what this is they are searches prepared by third-party providers for us. They can be anywhere from about 200 pages to, I had one that was over 3,000 pages, Also why you should not pick a merely descriptive mark. And this is just a inset photo of the cover of one of these clearance searches. This is an actual client. We just ran this report. I don't even know what day it is today, like 6-7 days ago. And you can see it came back with 4,200 US federal results. Now, 90% of those are going to be inapplicable. They rank them categorically from what we call a level 1, meaning this is a direct knockout. No way we're getting this through. Level 2, we suspect this will give you a likelihood of confusion. And then 3 and 4 usually don't come in. But as you'll see, the search also searches all 50 of the United States, which is of tantamount importance with hemp and cannabis marks. We'll talk about why, but pursuing a state registration strategy is oftentimes all that a hemp or cannabis company may be able to do, and you need to know if they are out there. It will also search all common law instances of the mark, including the whole internet, all social media, even alt text on images for us, and give us those results back. Next slide. Yes, Ruth, it does search the territories. Go ahead, Paul.
All right, so after your mark is cleared, we typically send an email covering that your mark is more or less good to go. It might have a few potentially confusing marks in the way, but we'll provide the client with that information, and then they'll authorize us to move along with the next step, being we'd create an intake form where they would review that, and then it would pretty much contain their entity information, what exact goods and services we plan on filing for. And once they give us the green light on that, then we are good to file with the USPTO. And for that, basically, you'll need to at least, if you're doing it on your own, but we'll most likely be doing it, but you'd create an account with the USPTO through the Trademark Electronic Application System. And from there, you would be filing, and the abbreviation for that is TEAS, T-E-A-S. So you'd be doing a TEAS Plus application or a TEAS Standard application. And TEAS Plus application is the most common type, whilst TEAS Standard application is typically more of the free-form entry. And a TEAS Plus application is $250 per class of goods and services, while TEAS Standard is $350. So if you're applying for smokables in class 34, cosmetics in class 3, and let's say beverages in class 32, you're looking at a $750 application typically. And that's mostly for use in commerce. There's a few other fees for an intent to use application. So a use in commerce application is when you're actually using your trademark in commerce, meaning that you're making sales across state lines to purchasers in conjunction with the goods or services that you're providing. So if under that instance, you'll be using the use in commerce basis, or which is under Trademark Act Section 1A. And also, if you're using in commerce, then you'll need specimens and dates of first use. So we provided a registration certificate here for Barbie, so I'm going to just use that as our example. So when applying for the mark, I'll need specimens of the goods, here being dolls, that prominently display the trademark of Barbie. And specimens is really just, I would need photographs, and it can be just simple. We typically ask clients for just cell phone pictures of the goods, like such as a Barbie that has Barbie prominently displayed on the box of the good or the good itself. If it was for website services, let's say for a blog, then I would want a screenshot of the website with, let's say it's a blog on Barbie, for Barbie, and I would take that screenshot and use that as the specimen for those services. And then dates of first use are, I would need to know the date of first sale in the state that the owner of the trademark is located in, and then date of first use in interstate commerce, which is just the date of first sale outside of the state that the owner of the trademark application is located in. And a lot of you, I'm sure, have seen my emails and CCs where I send multiple follow-ups to clients because often they're a little slow with this, but it is absolutely crucial to a trademark application. It's essential to achieve that ultimate registration certificate, which we've put here. But you can also file what's called a 1B application. And for that, it's basically if you're not using your trademark, but you have a bona fide intention to use it in conjunction with your goods or services, then you would use the 1B, Trademark Act Section 1B application. And I kind of covered fees, and Chelsea touched on timelines, but basically from the time that you apply, and let's say everything goes smoothly to registration, I mean, it typically takes closer to 15 months. But let's say if you get some of the office actions that Chelsea mentioned, and we have to provide legal argument and back and forth with the examining attorney who is assigned to your trademark application, then we've seen it take as long as 3 years. It could be a very lengthy process of back and forth, but I mean, I'd like to say that Chelsea and I are very good at what we do. So after time, we'll get you that registration. If you could hit the next slide, please.
No guarantees on getting you that registration. Moral of the story from Paul's spiel as well is don't make him chase you down to get these specimens or the use. I'm going to take a second to address some questions in the chat. That Barbie trademark, I suspect, was filed around the time that the movie came out, and they were filing a new stylized version. I just ran a real quick search on Barbie after that question, and number one, over 500 registered mark come up. When I limit it to Mattel and Barbie, yeah, it's still hundreds of marks. So you're just seeing they probably did a stylized iteration that was a little different than they did in the past. And that's why they're not claiming prior use because, and very astute question, Craig. I'm glad you asked that because a refresh resets the clock on usage for design marks because you're not using it in the same manner that you were. So it doesn't reset the clock on their word mark filing. It only resets it on the design mark because the design mark has to be the exact iteration of what was filed for. Now, there's might be a question, is there any benefit to state trademarking? No, I'm going to answer it from a legal perspective and then from a general perspective. So the question is there any benefit to applying for a state trademark prior to applying for a federal mark? No, indeed, every single state follows the USPTO basic standards on trademark registration. Now, they're not examining attorneys, so state applications rarely get reviewed with intensity, but you get no presumption or positive legal benefit from holding a state registration. Now, answering specifically for cannabis or hemp, obviously, if you are barred from federal registration, there is a ton of merit in pursuing a state registration strategy, but you cannot sue for nationwide infringement. And in cannabis, we've yet to even see a state versus state cannabis trademark dispute reach adjudication because due to its status as a Schedule I substance, cannabis is completely bounded by states. So how could Harvest Health in Arizona claim that it's confusingly similar with Harvest Health in California? Usually those are settled. We don't know which way a court would go on that yet. Now let's get into the nitty-gritty of cannabis trademarks. I'm also going to talk about hemp-derived trademarks as well here because both fall under the lawful use prohibition. So lawful use rule is something I'm incredibly passionate about. I am waiting to take this case to the Supreme Court. I just need to get the perfect plaintiff in the perfect posture. It's a pretty long path to do there, and I'm at the point in my stage where I'm about to do it pro bono. I rage against the lawful use rule routinely. The USPTO made it up in the 60s. It's not enshrined in the statute. And, the argument against application of the lawful use rule is that we know exactly what Congress intended not to be a trademark. And how do we know that? We went over it earlier in the presentation. It's line by line right there in the Lanham Act. These things can't be a mark. Absolutely nowhere does it say that use must be lawful. The USPTO would respond, somebody's going to try to register cocaine. What cocaine dealer do you know is going to go out and make a federal filing that you swear to under perjury that they're selling cocaine as a good? It's a nonsensical argument to me, but c'est la vie until someone takes this to Supreme Court. And the bench right now is so receptive to taking this down after in re tam. This is the confines that we must work under. So if the mark is used on goods or services that violate federal law, the USPTO will issue what's called a lawful use refusal. If it's not abundantly clear, I can't stand this rule because it has made examining attorneys become subject matter experts on scheduled substances, the Environmental Pesticide and Rodenticide Act, the Indian Child Welfare Act, meat and poultry. I mean, the list goes on and on. It's utterly ridiculous. If you apply for a cannabis touching good or a cannabis touching service, such as a financial servicing company that is actually touching plant touching enterprise proceeds, you'll get back this nice office action from the USPTO saying, thanks for trying, unlawful. It is a Schedule 1 substance, go home. I cannot fix that refusal. No one in the United States can fix that refusal. So with actual plant touching enterprises, we pursue ancillary strategies. I'm going to ask you, do you sell a lighter in your dispensary that has the mark on it? Do you have a rolling tray with the mark? Let me see your website. Do you have some educational blogs? There's a handful of what I would call ancillary classes. And it's funny because when I speak to trademark practitioners, I always get pushback on the way that alternative substances trademark attorneys use the word ancillary because it's a little bit different from how you would use it in a normal trademark term. But when I say ancillary, I mean, what else are you doing that isn't directly plant touching that I can get you on the register with? We have successfully registered hundreds of trademarks for cannabis companies across the United States. It can be done, presuming you choose a mark that falls somewhere on the sliding scale of descriptiveness. It's not confusingly similar, and we go for one of those ancillary classes. Now let's talk about hemp because cannabis is about to be headed the same way as hemp. After the passage of the 2018 Farm Bill, the USPTO at that point said, we will proceed with allowing registrations for hemp in limited circumstances. With the FDA announcement that it considers the inclusion of THC and CBD in goods that are ingestible within human mouth or within an animal's mouth to be illegal and adulterated products in U.S. commerce, the USPTO picked that sword right on up and said, well, all of you hemp companies that were now eligible, not so fast. The FDA says it's illegal. So instead of getting a Controlled Substances Act refusal, now you guys get an FDCA, Food, Drug, and Cosmetics Act refusal. Again, non-curable refusal for me if your good is THC and CBD inclusive. We can pursue those same ancillary registration strategies. Another mechanism I am a huge fan of is what we call a blocking application. And you'll sit with us and I'll tell you I can get you through in these classes, but where you really need to be is here. But it's not going to go through, but I still recommend you file, and here's why. Trademarks are registered in 45 different classes. It's subject to what we call the NICE classification system, which is an international treaty system that homogenizes trademark practice nearly worldwide, almost 200, I don't know if Papua New Guinea is following the NICE classification, but most developed countries certainly are. And as a trademark attorney, if you come to me and you say, I am going to do a after bath lotion, immediately in my head, I say you're in class 3 because it's what we've done for 30 plus years at this point. It's what Paul and I do every day. And I'm going to know what related classes to search. So when I run the full clearance search, none of those searches, I don't know if any of you noticed, but on the prior, it showed the categories we identified to search. Because there's no way in Hades I'm running a search on 45 classes. I'm going to get 15,000 pieces of paper back. And it's not relevant because if your bath bomb or your bath lotion is called, David, let's just go with David's. This is also why you guys see I'm an attorney and not a marketer. So you've got David's bath bomb. If there's a David's airplane wing, I don't care. There's no chance of consumer confusion there. I only need to know in the relevant related classes, is there a topical pharmaceutical application with this name? Is there, hairspray could be confusingly similar with that because it's unfortunately, in the e-commerce and mega grocery store, it's really given the USPTO an expansion of its argument on related goods, because it's like, well, if you can go buy underwear in Walmart, then your pepper might be confusingly similar to this underwear brand. It's gotten really ridiculous, but those 45 classes limit the search. A non-alternative substances trademark attorney, a trademark attorney who has never registered a cannabis, a hemp, or psychedelic mark, or has very limited experience, is going to go search those classes that I just said. They're not going to know to go search the ancillary services categories where we can actually get your registration through. I know I'm going to search some of those services categories in 35 to 45. They're not, and I see it every day. I get a call from somebody who's used a standard trademark attorney who's phenomenal at what they normally do, but maybe unaware of some of the quirks on hemp and cannabis race registrations. So I have you file that blocking application for two reasons. Number one, notice to a second comer. If someone else is trying to make a David's, CBD bath bomb, and bath bomb was a terrible example here because I actually can get that through if you don't make a health claim for me. But let's just say in a model world that you're saying this bath bomb will cure the common cold because it's got some menthol in it. I'm going to get a refusal there. And yeah, the USPTO examining attorneys are now experts on what a health claim is under current FDA regulations, which is insane because most attorneys aren't even experts on what a health claim truly is. So when they run the search, the non-alternative substance trademark attorney, they're going straight to class 3, 5, and a couple other corollaries. If we only pursue the ancillary services or the ancillary goods that fall into 34, or stickers or clothing, which is a strategy I've never recommended, I'm not a fan of it, they're not going to know you're out there unless they happen to find you on Google. So the blocking application, it's less than $2,000, usually sum total, to keep it on the register for, we can drag it out up to 3 years. And then for my larger companies, we simply refile the day it lapses. We're tying up the register both to provide notice and to preserve the place in line in the event that we see some form of federal legalization. So now let's talk what happens if cannabis goes into Schedule 3. Whole lot of nothing. For actual cannabis companies, instead of getting the Schedule 1 Controlled Substance Act refusal, congratulations, you now get the FDCA refusal that the hemp companies get, unless some iteration of the Farm Bill within the next year or so fixes the FDA issue. There is an examination guide that's been issued on hemp and CBD marks. It used to go to a very specific subset of examining attorneys. Now they go to more generalized examining attorneys, which frankly can compound the process. And some examining attorneys are incredibly experienced. We had a 30-minute phone call with an examining attorney like a month ago on what an atomizer was, and he knew. Like, he was very, very, very good at identifying what that piece of hardware was. So does anybody have any questions, or should I continue on with the hemp and cannabis spiel here? All right, I'll continue on. The second thing that I would have you do as a cannabis or hemp company, if we can't get you into the actual category that you should be in, I'm absolutely going to recommend that you pursue a state's trademark registration strategy. This gets very, very state specific. There are some states who will require, for example, a copy of your cannabis licensure before they will register their mark. There are states who require, Maine or Massachusetts, I'm blanking, it's an M. I think it's Maine, that requires an amendment to your company's certificate of formation to specifically state that it is a cannabis company. See a question in the chat. How does potential rescheduling of cannabis to Schedule 3 impact USPTO willingness to grant cannabis trademarks? That's what I was saying. Well, congratulations, you get the new FDCA refusal. And I'm going to say when, because I have optimism. When cannabis is rescheduled into Schedule 3, it qualifies it for standard pharmaceutical dispensation and production as a Schedule 3 pharmaceutical good, such as a steroid or coating. So to put that product on the market, you need to put it through clinicals in the FDA, and you do an investigational new drug application. You pass your clinicals and you get registered and approved as a Schedule 3 pharmaceutical drug. Most cannabis companies out there don't have this capability. The pharmaceutical CGMP requirements are quite onerous. It's expensive to get a facility. to pass through pharmaceutical grade compliance. So if you try to attempt, let's say, Kyle, you have a cannabis company and you primarily, let's go with smokables again, you sell pre-rolls, some vapes, maybe some dabs, something like that. If I apply today, while it's still Schedule 1, the refusal from the office is going to say, this is an illegal substance in U.S. commerce. It's a controlled substance, no go. If the DEA finalizes rescheduling, let's just say in a model world, they're done by April 1, and they won't be, don't anyone get your hopes up. Then I reapply for you, and I wouldn't, because I'm going to tell you, you know, where's your Schedule 3 clinical approval here. If I happen to reapply with that same smokable category of goods, now instead of the controlled substances refusal, and they may still give it, it could be dual refusal, but the primary bar that you're going to face at that point is what's called an FDCA refusal, a Food Drug Cosmetics Act refusal. And it would be a refusal based on the fact that the cannabis good that you are trying to apply for has not been approved for circulation in interstate commerce as a Schedule 3 pharmaceutical drug. Hopefully that answers the question. Hearing none, I'm going to assume that it did. Okay, perfect. If what we're all on pins and needles for is if the next Farm Bill iteration is going to fix the FDA issue, some of the drafts simply direct the FDA, you know, fix this issue. The FDA has been very clear. They took 5 years to look at it and came back in January of 2023 and said, oh, well, it's been 5 years. We can't do anything. We are statutorily bound by what's called the exclusionary rules if an article has been included within a prescription drug as an active ingredient and is ineligible to be put into a mass consumer product or consumer product period in interstate commerce. So THC and CBD, both ingredients in prescription drugs, Epidiolex, Marinol, Syndrose, and according to the FDA, there's no evidence that THC and CBD derived either from hemp or cannabis were sold in interstate commerce prior to the date that the investigational new drug applications, or ANDA as it's called now, new drug applications, were filed. There is an exclusionary kick-in that says if the substance was sold in U.S. commerce prior to the date that investigational new drug filing was done, then it remains eligible for sale. The FDA has sat on its laurels and said they received zero evidence that any of these substances were sold prior to those investigational new drug applications. And as we see pharmaceutical companies come online, Schedule 3 is going to make it phenomenally easier for qualified research institutions to receive a Schedule 3 license. Schedule 1 right now, nigh impossible to get. You're not getting it. You're wasting your time and your money. You'll see more pharmaceutical formulations targeting specific cannabinoids, you know, CBN, CBG. There's over 120 something phytocannabinoids in the plant. And if those are approved for pharmaceutical drug usage and it cannot be proved that they were circulated and disseminated widely in interstate commerce prior to the date of that investigational new drug application, then this potential bar that we have right now that only applies to THC and CBD could be expanded to other phytocannabinoids, which is this is why I love what I do. It's absolutely fascinating. It changes every day. So that is a very brief summation of cannabis and hemp marks. There is some specific language that we need to put in when we apply on the hemp side, and it's basically certifying to the USPTO that the good contains less than 0.3% THC on a dry weight basis. Another quirk is if you are a hemp-derived company, it doesn't matter if after the 2014 Farm Bill you started selling. I have clients who have usage back to 2013, 2010-ish. The USPTO found, in their opinion, they're wrong because there's an entire brief at the Ninth Circuit where the drafters of the 2014 Farm Bill said, nope, that's exactly what we intended was use in commerce to be eligible for sale, for commercial sale across the United States. But the USPTO took the position that the 2014 bill did not allow for sale in interstate commerce. So if you have a hemp good that you have been using and selling in U.S. commerce prior to December 20th, 2018, which is the date that then acting President Trump signed the 2018 Farm Bill, The USPTO will not permit you to claim prior use dating back to 2010, 2013, whatever your date of first use was. You must put on your application a date of first use of December 20th, 2018, which is also fascinating to me that we haven't seen a huge rise in litigation in that sphere, because there are thousands of marks on the principal register in the hemp industry, all for the same goods and services, all claiming a date of first use of December 20th, 2018. And I suspect, litigation will be coming, and it will be interesting to see what the courts do there. They can look back on some of that prior use. That is probably enough for me. I talk quickly because I have a lot to get out, but let's leave about 5 minutes for some Q&A on here. No questions. That's
Chelsea, it looked like there was some questions in the Q&A, not the chat. One was the Barbie one, which we got, but there was a question about once an application has been accepted, what is the current typical timeline for examination and approval of the mark?
So they were running behind. Let me actually pull it live for you right now, because I know they just updated what the examination timeline right now. The wait time right now, they are currently processing applications filed April 17th, 2024 to, I'm not sure why I have feedback, to May 1st, 2024. So they've actually sped up. How long ago was April? Like 6 months. So they've shortened the wait time. It typically is 9 to 12. Is it as important to file USPTO and let's say the state of Connecticut are both crucial? So I have a question. Is it as important to file at the USPTO and let's say the state of California are both crucial, or just USPTO? The federal registration is always what you want first. It provides a nationwide presumption of usage and a prima facie application of certain evidentiary privileges in the event of litigation. So always USPTO first. If you're wholly unable to get into the USPTO, pursue the state registration. It gives you protection within your individual state. Good. All right, I think I have all the questions. Jay, there's it's a specific question about your specific mark. I would recommend reaching out to an IP attorney, if not us, simply because 2 other companies are using the name is not probative, not enough information to assess that. Plus, I'm not your attorney, so I'd need to see what the other usage instances would be there. But if there are other companies who are using your name and you hold a federal trademark and they're using it in similar goods and services in a confusingly similar manner, you likely have a basis to send a cease and desist. Welcome. Also, I want to thank the audience for y'all's participation. I love it when we get good questions and notes on these.
And Chelsea, maybe you could just talk a little bit about if you have a brand and you don't have any protections and you get a cease and desist letter, and assuming that the company that's sending you the cease and desist letter has a legitimate claim to the trademark, what does that mean for you? Like, what are your options, or what, in worst case scenario, what would happen to the brand that you've spent money establishing, thinking that nobody else was using it?
Well, as an initial matter, that's why we recommend this whole clearance process, because this happens daily. I mean, Brandon, we just did it with a joint client. So when you fail to clear and pay the price later is usually what I tell people. So when a demand letter comes in, if you're pleading common law usage, I'm not going to say I don't take it as seriously, but when I receive a cease and desist that has an attached federal registration, I already know if this goes to litigation, these guys get a prima facie presumption of ownership. I'm going to need to attack their mark in some way to overcome that. So I take it pretty seriously. Then we're going to assess the merits of the letter to say, is there a chance of consumer confusion? And a lot of times in the cannabis industry, people will send almost test letters out where they're demanding you cease use, but it's a dispensary in California and they're sending a letter to somebody in the state of Florida. Zero chance of consumer confusion there because of I'm sorry, I don't know why I have feedback, so I apologize to the attendees on that. But usually they're just looking for someone like me to respond back and say, yeah, you know what, we'll enter into consent agreement that in the event of federal legalization, you guys stay over there on the West Coast, we'll stay over here, we'll respect our respective territories here. If it is a larger company that has a lot of resources, that often changes my analysis, because with larger companies, if I am representing a corporate behemoth that dedicates 1% of their entire revenue onto IP spend, I know that I've got the funds behind me to haul off and file a declaratory action. If I get some sassy response from you, it's almost like a, well, I'll show you mechanism, small little shop, like, let me haul off to federal court and file a declaratory action and adjudicate my client's rights here. There is a lot of risk in responding to demands because of that. I've filed declaratory actions plenty of times to get a substantive adjudication of the right. Generally, 99, yeah, I'd say 99% of the time we settle these through either monetary payment is always my last resort. I, as your attorney, I don't want you to have to turn over a chunk of money. We can do things such as phase out on usage. I work with you on rebranding and choosing the appropriate mark, and then we go back to the other side and say, look, we respect your IP. You know, let's get an amicable resolution here, and we can work out what we call a sell-through period, where generally the entity is given anywhere from, I mean, I've seen as fast as 60 days to upwards of 2 years to sell through that existing inventory.
Great. Thanks, Chelsea. Looks like, did anything else come in? There was a few more. I mean, we're running out of time here, but Chelsea, if you want to look in the Q&A
Yeah,
chat.
so I see one saying, is inclusion of marijuana in the U.S. pharmacopoeia in the 1930s not considered widespread use because of the subsequent Schedule 1? You know, there are 1,000 usages I feel like the FDA could have relied on. I mean, we have use that is closer in time. I mean, there's an entire Ninth Circuit case in the early 2000s on hemp-derived THC and its sale in commerce. But for some reason, the FDA has come back and said that that is insufficient. So no, they don't consider that sufficient usage for application of the exclusionary rule. But partially why is we didn't have the CSA in the 1930s. The Controlled Substances Act was adopted in 1970. Natasha, can you clarify what you mean on, is there a way to identify cease and desist letters quickly? I'm not sure I'm understanding the question. The legitimacy. Yes, the first thing I'm going to do is check that registration. It will come with, the letter will have U.S. registration number, yada, yada. And on tests, remember the video that we walked through, in that pull down menu, you can pull it down and choose either serial number or registration number, and that's going to bring up their filing. That's exactly where I start, because the filing is going to tell me what claimed date of first use they have. So oftentimes I get a letter from somebody saying, you know, hey, my clients use this since 2021, here's our registration, and I get to respond back, joke's on you. My clients used it since 2014. They just failed to file an application. We filed, you stop. So that's where I start as a preliminary matter. The second would be when you're looking at legitimacy, excuse me, I go to see how they're using the mark. Is it protectable? What are they using it on? What are the instances of actual confusion? The likelihood of confusion analysis is guided by a 13-part factorial analysis called the DuPont factors, which I'm not going to bore you with, but every circuit has a different subset of what they've adopted as the DuPont factors. So depending on where the letter's coming out of, where they're going to sue me, that's what I'm evaluating under.
All right, thanks, Chelsea. I think we're out of time here. If we didn't get to a question, definitely email us or we'll email you. And if you have any follow-up questions, here's our contact information below. Paul, Chelsea, this was incredibly informational and super important for businesses. So thank you guys for taking the time. And everybody who joined, thanks for joining us. This was a good webinar.
Thank you all very much. I appreciate it.
Yeah, thank
Thanks,
y'all. I
Brandon.
dropped my email in the chat. Paul's is the same as P.Stevenson. Brandon's will be B.Kurtzman at Vicente LLP. Get your trademarks registered, everybody. Thank
Happy
y'all.
holidays, everyone. Take care.
Thank you.